Thank you so much. Namaskaram, everybody. It is indeed an honor to be here and amongst all these people here, and to be able to share my impressions about a man who in his own rights is a great legend. I will try to do it, of course, but it's like that little, doll, made out of salt, going out to actually, measure the entire ocean. So, let me start by saying that I am in awe of this man, okay? I admire a man who is able to leave an excellent job. He is liked in that job. He is doing so well in that job. And he leaves that job and says that I would like to start something on my own. Entrepreneurs, I think, are a breed apart. And he was one, actually, quintessentially. Number two is, more than that, he has been able to leave an MNC, and I'm saying this because I wear India on my sleeve, and to start a homegrown Indian agency that was to, in time, grow into one of the largest integrated Marcom organizations that you had a look at. I was told, of course, and I knew about it even then, in the 80s, that he was amongst the earliest people to actually court PSU accounts, public sector accounts. Now, this was the time when the large MNC agencies would not go anywhere near them. Now, to me, it shows actually two things. A is, here is a man who could actually, sense an opportunity that others had not been able to sense at that time. And B, here is a man who had great faith in the entire India story, even then. Now, I too had just actually, started my agency in the mid-80s. And I was also, trying for some of these PSUs. And here is where I actually, saw the great man himself for the first time. So, ONGC had actually, called for a pitch. And lot of agencies were there in that hall. One herd of agencies was there, and I was there as well. And the lady who was handling that, was in a hurry. And she was saying, hurry up, next, this, that, and all that. So when my turn came and our agency was asked to go in, I hurried up there. I was a little kind of tense and all that. And I had the slide tray with me. Those were days when AI meant Air India. Okay. It's not all the things that we now hear about. So I jumped up from the chair and I hurried in, and all the slides fell down. So I was absolutely, flummoxed, because to put them back in the right order, this, that, and all, it'll take time. And the lady was in a hurry. And an executive was there who was herding me in. At this moment, R.K. Swamy came up. And he said, take your time. Don't get nervous by all these things. Okay, take your time. So I said, but he's saying, come fast. So he said, wait. And he walked up to that man. He obviously knew the man well because he was already handling the account, ONGC, and he was up for re-empanelment. He spoke to him and said that, look, I'll go now. He can come next. So that man said, okay. So I was able to get another 15 minutes to slowly collect the slides and my wits. And this story, of course, had a nice happy ending because both R.K. Swamy and our agency got empaneled. However, to me, it also showed that here is a man whom all of us knew was extremely competitive. At the same time, was also kind. And he felt there is this youngster here, raw fellow. Let's not, rock the boat even more for him. And my respect for him, grew a lot more. After that, of course, I used to hear in industry circles that he's extremely strict, and he is a little legalistic and very tough and all that. I realized that he was all of these things when he was arguing the advertising agency industries part of the story. And I had heard this story from other parts of our industry, not the advertising agency part of our industry. So he was a man who was keen to have the industry's interest in his mind, uppermost in his mind. Now, apart from all this, I think, at a more personal level, I was impressed when I heard that he gave equal importance to education to the boys and the girls in the family. At a time when it was not as, I think, common as it is now today maybe. Even more impressive is the fact that while he was on a trail of building this huge enterprise, he somehow had the time for a host of other things. Whether it was social work, educational institutions, medical institutions, religious institutions, rebuilding or restoring shrines. He had the time for all of these things, and in all of these things he was able to actually do it well. So when I said perfectionist sometime back on another note to his son, but here is the real word, I think perfectionist fits the bill. Of course, I am glad that after, at the end of the day, how is a man actually, measured? I believe it is, mostly by the entire legacy that he is able to leave behind. And R.K. Swamy has been able to leave behind a rich legacy. And everything about the things that he had done were only expanded upon, grown, and have done so well. At the end of this, I must say, if you noticed, I never, used the term late R.K. Swamy. Because I have always felt that to live in the hearts that we leave behind is not to die. And R.K. Swamy lives in our hearts, in our minds, in the organization which he has been able to establish in the schools, hospitals, and the future of all the kids who are being helped even now, the religious institutions and all that. And all that, I think we all owe him a great, debt. Thank you very much.
Thank you, Mr. Ramesh, for sharing your impressions. Swamy, very inspiring. Now we are come to the most awaited moment, our chief guest lecture on succession planning, myths, reality, secrets, with specific reference to wills, settlement, and nominations. Ladies and gentlemen, put your hand together. Welcome to deliver the memorial lecture, Honorable Lordship Justice Mr. Balaji. And may I have a
Honorable Mr. Justice P. B. Balaji is a distinguished judge of the Madras High Court, appointed on February 7, 2023, and sworn in as permanent judge on September 24, 2024. Educated at Padma Sheshodri, Chennai, and Madras Law College, Justice Balaji honed his legal skills under the mentorship of his father, renowned civil lawyer Mr. P. B. Ramanujam. Known for his meticulous preparation and persuasive advocacy, Justice Balaji's career reflects excellence in legal practice and judicial service. His appointment to the Honorable First Bench highlights his significant contributions to the judiciary.
Ladies and gentlemen, it's my proud privilege to present to you Justice Balaji to deliver the 6th R.K. Swamy Memorial Lecture. Justice Balaji.
Very happy evening to all the distinguished guests, respected Sri Shankar Jiwalji, the family and friends of legendary and visionary Sri R.K. Swamy, members of MMA who are present here, ladies and gentlemen. Mr. Srinivasan Swamy gave me the invite. On going through the invite, I found a very strange and interesting coincidence. The invitation talked about journey of Sri R.K. Swamy. He was born in 1922. He started R.K. Swamy advertisement in 1973 at the age of 51. I was born in 1973. And today I am 51 years old. Is it a coincidence? I don't know. Probably it's just destined to be that way. At the age of 51, he started R.K. Swamy advertisement, and I am here at the age of 51 to deliver the memorial lecture. Be that as it may, the topic which I am going to address is actually a very serious topic, which is very important for each one of us. But at the same time, especially when it comes to wills, it also gives rise to a lot of funny anecdotes. Because when people and property come together, there's bound to be drama, comedy, and tragedy. All of us will like our properties after us to go in a particular fashion. Of course, there may be exceptions. Some of you here may think, I don't want to plan anything. So this one is for you, the shortest will ever. A very rich man who lived a very king-size lifestyle, but very private lifestyle, called his lawyer and gave him a sealed cover and said, this is my last will. I want you to read it only after my demise. Don't reveal it to anybody when I'm alive. So the lawyer took it, and after a few months, the rich man passed away, and all his relatives and friends assembled, eager to know what was there in the will, whether they are going to be benefited by the will. So the lawyer opened the cover and read out the will. That old man, the rich man, had said, I was wise, I spent all my money. So this is for people who don't want to plan anything. You enjoy life, spend whatever you earn. But probably the majority of you want to leave something behind for your family, for your well-wishers, or probably do charity also. So wills, I'll probably distribute the topics into three. First, wills, settlements, then I'll go to nominations. First, let us deal with wills. So as you all know, will is a document which expresses your last wish. the manner in which you want your properties to go, be it movable or immovable, after your lifetime. It is very simple to draft a will. Of course, it is always better to consult a professional lawyer. Do yourself. They call it DIY. Do it yourself. DIY. So will is something like a DIY. You can draft your own will, very simple, which I'll give you inputs. But better get it vetted by a lawyer, because spending a few thousands now will save you lakhs of rupees in litigation later. So you'll have to consult a lawyer and vet your will. The will, as opposed to a settlement deed, is not a transfer of property. It is only a document by which title is devolved on the beneficiaries under the will. Therefore, it will not come under the definition transfer of property. Will is very simple. There is no particular form for writing a will. There is no language that, like in any legal document, suppose you want a sale deed, it has a particular format you have to follow. Nothing of that is required when you want to draft your will. You just express your wish. It can be on a plain half sheet of paper. It can be on a page in a diary. It can be on a stamp paper. It can be on the cover of a book. The requirements of a will, which I will take you a little later. So the simplicity is the prime advantage of a will. The will need not be registered. A lot of misconception that will should be registered, not necessary. The will still has equal effect even if it is unregistered. So that is the biggest advantage. With the comfort of your home, you can write your will. The other advantage is you continue to keep control of your assets. The will takes effect the moment you die, the maker dies. Therefore, that is the biggest advantage over a settlement deed. In a will, you continue to control what assets you can even sell the assets. Even though you have written a will saying that my property should go to my children, you are still entitled to sell that property during your lifetime. Just because you have written a will, your right does not go away, it's not taken away. So that is one big advantage. When there are specific bequests you want to make, you can write a will. But first question is, when do I write a will? Should I write a will? Is probably the biggest question which comes to us first. Yes, you will have to write a will if you want to alter the line of succession. So I'll give you an example. There is a happy family. Man married happily to his wife. They have a son and a daughter. The man owns a 3-bedroom flat in, say, Senate Off-Road. He wants his wife and children to take the property equally. So there is no necessity for that person to execute a will, because he wants to write a will which is in line with the line of law of succession. So therefore there is no necessity to write a will. But suppose the same person wants to give the property only to the daughter and not the wife and the son, then he has to write a will, because he wants to alter the regular line of succession. We are governed by the Hindu law, the Indian Succession Act for Christians, Hindu laws for Hindus, and the customary law for Muslims. Therefore, if you want to alter the law of succession, definitely I would advise you will have to write a will. The second point is, suppose you have multiple properties. You want to give clarity to your family legal heirs, saying that property A will go to my wife, property B will go to my son, jewelry I leave behind will go to my daughter. Then you should write a will. Because when you leave behind the entire estate, the family may not have a direction to how to distribute the properties. Therefore, in such circumstances, you can write a will. But if you don't want to alter the line of succession, then you need not write a will, because automatically it is going to be taken that way. The execution part of a will is the most important limb of wills. Because, as I said, wills need not be registered. It can be on any piece of paper, even on stamp paper, but there is no requirement that it should be on stamp paper. Minimum of 2 witnesses. This is the most important part of the execution of a will. Minimum of 2 witnesses will have to attest your signature. It can be written in your own handwriting. It's called a holograph will. It can be typed by somebody. You can sign at the bottom. But if there are corrections, please make an initial across the corrections to avoid any future complications. So date of execution is very important. Place of execution is very important, because in 3 presidency towns, probate of the will is compulsory even today. The presidency courts of Madras, Bombay and Calcutta, if the wills are executed within the jurisdiction of these 3 courts, then the will have to be necessarily probated before the High Court, or the district court. If it is outside, it is not necessary. But suppose you write a will in Bangalore, but the property you bequeath under the will is in Chennai, then you will have to probate the will. So there are twin conditions. Either the property is within the 3 presidency towns of Madras, Bombay and Calcutta, or the will itself is executed within these 3 presidency towns. So these are the twin conditions where probate will be required. So therefore you can make a will which has a lot of clarity, and you spread out the reasons why you choose somebody over somebody. So normally the will, because the problem is today there is a lot of litigation in so far as wills is concerned. There is no necessity that you should state reasons. There are wills which are 1 sentences, 2 sentences. In fact, one man called his wife and said, the advocate and said, I want all my property, everything to go to my wife. The lawyer dutifully wrote a very short will, described the family, and he said, everything should go to my wife. But son was very clever. He went to a seasoned property lawyer and he said, by everything he meant only the belongings in the house, not the bank assets, bank balances. Will was contested, litigation went on for years. So therefore, you must make very clear that what you want to bequeath under the will. It can be both your movable properties, immovable properties. You can choose to bequeath only a portion of your estate. One portion you may want it to go as per the regular law of succession. You need not include it in the will. There is no compulsion that you will have to include all your assets. Suppose you want to give one particular property to your son. For that property alone, you can write a will. Leave the law of succession to take its regular course insofar as the other properties are concerned. So these are very important. Coming to execution, 2 witnesses will have to see you sign the will. Because the man who wrote the will is not going to be alive. Tomorrow the will is challenged in the court. The witness's role is most crucial. Therefore, 2 witnesses, choice of witnesses is very important. You will have to choose. I see a lot of people who come to me when I was a lawyer. They are my best friends. I've known them for 60 years. I want them to witness the will. It is not a good suggestion to have very old people sign the will, because they may pass away even before the maker of the will. Therefore, choose young witnesses who will be around for, say, 20 years, 30 years to speak about the due execution of the will. So that choice of the attesting witness is very important. Then, as I said, first you sign the will, then the 2 witnesses sign in the presence of the testator. This is the requirement of the law. So the will is signed by the testator in the presence of 2 witnesses who sign in the presence of the testator. There may be cases where you have only 1 witness. You may ask me, is it possible to write a will? It is possible. The will is signed in the presence of just 1 witness. Then that witness goes. Tomorrow, the executant calls another person and says, see here, this is my last will. I've already executed yesterday in the presence of Mr. X. I want you to attest as the second attesting witness. Law permits this. Therefore, each of the witnesses should sign in the presence of the maker, who is called the testator. So that is very important. Not necessary that both the attesting witnesses should be there at the same time. So this is one factor you can remember. But ideally, it is always better to have 2 witnesses who are known to you, should not be strangers. We lawyers find a lot of difficulties where wills are registered in the sub-registrar's office. There are witnesses who are stock witnesses. Somebody who works there as a drafting person or an office boy, they are called to witness. But when the will is challenged in the court and evidence is required, say after a decade, persons are not able to find out the whereabouts of the attesting witnesses. So they must be known to you and preferably of young age. Next question that may crop up, whether a beneficiary can be an attesting witness. Ideally, there is no bar except insofar as Indian Christians. Under the Indian Succession Act, there is a prohibition for a beneficiary to be a witness, an attesting witness to a will, only insofar as Indian Christians. Insofar as Hindus, Buddhists, Sikhs, Jains, there is no prohibition. But my suggestion, always better not to have the beneficiary attest the will. Because tomorrow that is going to be one of the grounds on which challenge is going to be made, saying that he had played an active role in bringing about the will. Therefore, avoid beneficiary being one of the attesting witnesses, though there is no bar. Any person who is over 18 years is entitled to make a will. Even an unsound person of unsound mind, when he is of sound mind, the period when he is of sound mind, can execute a will. A blind person can execute a will. Deaf person can execute a will. Therefore, there is no bar proof of will is most important. Therefore, the only persons who are going to speak about the will are the attesting witnesses. So choose them wisely. Then registration. I said registration is not compulsory. Courts have time and again said, right from the 1950s, Supreme Court has said, High Courts have said, registration does not confer any special status on a will, because it still has to be proved by examining at least one of the attesting witnesses to requirements that he saw the testator sign. He signed in the presence of the other attesting witness. Witnesses signed in the presence of the testator. This is the requirement of law to prove a will. Unlike any other document, suppose a sale deed is executed, you need not examine the attesting witness to prove a sale deed. But whereas for a will, you will certainly have to examine one of the attesting witnesses to prove the will. So therefore, make it very sure that the witnesses are known to you and they are around, they will be around for in case of any matter going to court and evidence being required. Registration is not compulsory, but the only advantage of registration will be, suppose the will is lost, you can get a certified copy. That is the only advantage. Suppose there is an unregistered will. The second son knows I am not a beneficiary. He may tear it up. He may destroy the will. The wishes of the maker go unfulfilled. Therefore, it is very important that will is made available for the wishes to take effect. So therefore, this aspect, registration, is probably advised. The other disadvantage of registration is, suppose you register the will. Tomorrow you change your mind. You want to write another will. You are already 80 plus, you are unable to go to the sub-registrar's office. And that again creates a doubt or a suspicion that why the original will was registered, first will was registered, why not the second will? Second will was not is unregistered. So to avoid that, preferable to register the second will also. So these are the advantages and disadvantages of registration of a will. But courts have repeatedly said, just because a will is registered, we will not accept it. You still have to prove it in a manner known to law. And insofar as Hindus and Christians, there is no bar, the entire estate can be willed. But when it comes to Muslims, as per their customary law, they can't write a will in excess of 1/3 of their property. So you can limit your will only to 1/3, but you can gift it by way of hiba, even an oral gift, or a settlement deed to your near and dear. But if you want to write a will, there is a restriction that it cannot exceed 1/3 of your property. So these are the facets of a will. It's very easy. You just write what you want, get it vetted by a lawyer. Today, even AI is going to help you. But the AI will not give you a human approach. It may throw up very complicated propositions which cannot be practically workable. So you still better, I think, go back to your family lawyer or a good property lawyer who can advise you on writing a valid legal will. Coming to settlements. Settlements, as I already said, is a transfer of property. It is between two living persons. So when do I settle? When do I write a will? Suppose man is completely satisfied. I've lived my life. I don't want to hold on to any more property. I want to give it to my children even during my lifetime. Then you can choose to execute a settlement deed. So settlement deed, the tenor of a settlement deed is that the effect of a settlement deed is that the title gets transferred the moment the settlement deed is executed and registered, unlike a will. The will gives you a lot of flexibility. You can tomorrow choose to cancel that will, execute another will. The last will prevail. That is why we call it last will and testament. The last will prevail. Suppose there is contradiction in the earlier part of the will, later part of the will, later part will prevail. Suppose in the earlier part you say, I give all my property to my wife. But towards the end you say, no, I want all my properties to be taken by my children. So bequest to the wife will go. Because the last intention was to give it to the children. But unlike in a will, in a settlement deed, the first part will prevail. The later part will not prevail. So you suppose there is a contradiction in a settlement deed. First you say, I give life interest to my wife. Thereafter the property should go to my children. But later on it says goes absolutely to the children. The wife's life interest will subsist. It will bind the children. Because the first part, the moment you declare in a settlement deed, it takes effect. It is not like a will where the later will prevails. Therefore, this you will have to be careful. Settlement deed, as I said, it is not revocable, unlike a will. That is one disadvantage. Suppose you settle it, saying that your children will take care of me in the last evening of my life, but tomorrow they throw you out of the house. This is happening. Very hard fact, but it is happening. In such cases, there is a provision where you can still retain a little control over the asset, saying that, yes, I transfer title today by way of a settlement deed, but my wife and myself will have a right to reside in the property, or suppose the property is rented out, right of rental income can be retained. But you cannot retain a right to alienate or encumber the property. Then it becomes a will. So that is the difference between a settlement and a will. So condition can be very limited. And courts are also taking divergent views. There is some courts say you cannot impose conditions. Settlement has to be accepted as it is. It can't be a conditional settlement. Some courts have said, especially after the Senior Citizens Act has come into force, you can impose conditions saying that my children should pay me 20,000 rupees a month. Subject to that condition, I am settling the property. That condition can be enforced. Some judges have taken that view. Supreme Court has taken a different view. The law is not yet fully settled on this issue. So therefore, you now have a choice. You know what a will is about, what a settlement is about. You need not do a settlement deed in case you want to retain control and have flexibility. There is a document called a codicil. See, suppose in a will, you want a minor tweak or change to be done. You need not redo the entire exercise of writing the will. Suppose I have named my niece as the executrix of the will. You can name a person who will be in charge of your estate. He is called the executor. The person who writes the will is the testator or the testatrix or the executant. But you name an executor or multiple executors who will be in charge of your assets on the moment you pass away. They will take control, ensure that your wishes are fulfilled. So that it is always better to appoint an executor. So that person with whom you have confidence, you can appoint, so that it ensures that the will take effect and will be given effect to. So therefore the executor will take control of the assets. They will distribute the assets as per the will. It's easier when you go to probate also. Suppose the will does not have an executor. Still the will can be administered. It is called letters of administration. You will not be given a probate. The High Court or District Court will grant you a letters of administration. Only a beneficiary can approach the court for letters of administration. Whereas executor can be even a friend, a neighbor, or your colleague, anybody whom you trust, you can name them executor. Executor can be the beneficiary also. There is no impediment for the executor not being a beneficiary. He can be the full beneficiary. And you can still make him the executor. So executor will file a petition in the court for probate. You get in the presence of the legal heirs, prove the will by examining the attesting witnesses. You will get probate. Outside these presidency towns, probate is not compulsory. Even today, suppose property is in Delhi or Bombay, will is written in Delhi or Bombay, then probate is not required. So therefore, and coming to codicil, suppose I have named Mr. Narasimhan Swamy as the executor of my will. Tomorrow he goes and settles down in US. So I can't expect him to come to Madras, stay here for 6 months, probate. So therefore I can change the executor, for which I need not rewrite my entire will. I write a document called a codicil and says on so and so date, I have executed my last will and testament. Because of so and so reasons, I am necessitated to change the executor from Mr. Narasimhan Swamy to Srinivasan Swamy. That can be done by way of a codicil. But codicil again, execution is like a will. It will have to necessarily have two witnesses, and it has to be executed in the same manner in which the will is executed. So this is a document called codicil, which many of us may not be aware. This is so far as wills and settlements. Then nominations. Nominations is probably most misconstrued procedure, an illusory. What can I say? People think the nominee becomes the owner, which is not true. Even in 1984, the Honorable Supreme Court settled the law saying the nominee is only a trustee for the legal heirs. Just because you are nominated, you do not become the owner of the assets. In fact, I was sitting in the division bench, one case came up before us where the brother-in-law was appointed as the nominee. Wife and daughter were the legal heirs who would otherwise get the property, the bank deposits and bank balance. So this brother-in-law said, no, I have been nominated. I have been his favorite brother-in-law. Therefore, he has given me nomination, therefore property should come to me. Matter went to the writ court. because the bank said, you get a court order, we are not going to release, because there is an objection by the legal heirs. Otherwise, it will be paid to the nominee. But when there is an objection, matter went before the single judge. Single judge said, you are not entitled, you are only a nominee. Then it came up before us, before the division bench. And the same argument was put forth, saying I was his favorite person. And there was a will executed by the deceased person, giving the property to the daughter. We said, you are not named in the will. You are not a class 1 direct legal heir. You are only a nominee. So in a lighter vein, I told him, you are only given the ATM pin, not the balance. So that is the status of a nominee. Like recently, about 10 days back, the Lok Sabha has passed the amendment bill to the banking amendment bill, I think 3rd of December, where now it is permissible to have 4 nominees. Can be simultaneous or successive. So till now, so far as your bank accounts or bank balances, you can have only one nominee for insurance policy. Now it is expanded to 4. So you can say it is simultaneous or successive. But insofar as bank lockers, it is going to be only successive. But still the position, even after the amendment, does not change that nominees will be only trustees. It's like a postman. You collect, distribute it as per. The nominee may be one of the beneficiaries, but he cannot say, I will take away the entire assets or estate because I am a nominee. So this is with regard to nominations. I may have given you a few amusing anecdotes, but the entire process of doing these documents is to achieve an end, specific ends. So these are means, wonderful means to specific ends, provided it is done carefully and with proper planning. My experience as a judge in the last 22 months, I have seen property disputes not bring out the best among the litigants. In fact, brings out the worst in the litigants. So I feel laws can also be used as a preventive measure, not only for resolving disputes. So if you are going to take proper advice and do some little planning, you can certainly avoid all these litigations. The greatest charm of doing proper estate planning is that it brings eternal peace to your family members. It gives you a sense, it gives them a sense of direction. Because it is your property, you are the maker. Nobody can question your decision to give it to X, Y, Z. But ultimately they know that there is a clarity, there is a sense of direction that your will or a settlement provides, a nomination provides. Therefore, if it is used carefully, I think there is no problem. If you don't want peace, at least leave some fees for your lawyer. Thank you.
Thank you, sir.